Probate documents are one of the best primary source documents out there, but they're also one of the most complicated. Where I see the most confusion, though, is understanding guardianship, especially in colonial and early republic probate proceedings. I'm Mike O'Neill, and I'm going to give you an overview of guardianship, if I can, in just 5 minutes. If you want to dig deeper, I recommend spending some time at Bob's Genealogy filing cabinet at genfiles.com. It's a great site, lots of good information. And actually, I'm going to start with a couple of quotes from that site's Orphans and Guardians article, which really does a fantastic job of providing historical perspective. And I quote, "For most of history, an orphan was a fatherless child, irrespective of whether the mother was living." The guardian's responsibility was focused on the property of the orphan, not on the orphan himself. The primary purpose of a guardian was to provide for the management of the orphan's estate and to use that estate for his maintenance and education. Guardianship thus had nothing to do with physical custody. Courts almost always assumed that orphaned children would live with their mother if she was alive and capable of rearing them. Honestly, if you can internalize that, then you can stop watching this video. You've got the message. Guardianship was about finances, not about raising a child. Of course, I have a few things to add, along with what I think is a great example of how guardianship can be misinterpreted. All right, first off, pay close attention to when the courts assign guardians. Many courts will note in the record that a child was below or above a certain age. For probate proceedings taking place over many years, you can get very accurate estimates of when some of the children were born. Now, why do probate courts do this? Typically, children had different rights depending on their age. For example, in Pennsylvania, a minor below the age of 14 was assigned a guardian. Minors above the age of 14 could request the court assign a specific guardian of their choice. The second point is that probate was a family affair. When courts assigned guardians, they typically chose close family members to play the role. As an example, I have been struggling for 3 years with the role of two brothers, Thomas and Joseph Chu, as the guardians chosen by Nancy Chu Overman. I can't figure out how Nancy was related to the two men, and the widely accepted genealogy puts Thomas and Joseph as siblings to a completely different Nancy Chu, which could have made Nancy Overman a 4th or 5th cousin possibly. The third thing about guardianship that you have to realize is how different education is today compared to just a century ago. In 1919, only 17% of high school students graduated, which was nearly triple the rate of 1900. In comparison, in 2016, 84% graduated high school, and they graduated on time. Even more graduated high school. Now go back to the 1800s, high schools didn't even exist. Education happened in a one-room schoolhouse, and that education stopped after the 8th grade. Now, if you go back even further to the colonial era, your education happened on the job, either from your parents or via an apprenticeship. For example, in colonial Pennsylvania, apprenticeship was such an important educational path that the 1713 interstate probate law granted courts the explicit power to place a minor orphan into an apprenticeship or other form of employment upon the request of the guardian. Now, why is that important? If you see a probate document where a child was handed off into an apprenticeship, you might think there's like a wicked stepfather thing going on. That wasn't the case at all. That's how you got educated. So let's look at an example of how to misinterpret guardianship. Here's an excerpt from a genealogy of the Slow family in Pennsylvania. The story told here is that a wicked stepfather banished his stepchildren from their home and placed them into the care of guardians on nearby farms. Well, you can already see the problem right there. The author equated guardianship with custody. What really happened is that when Philip Slow died intestate, his children were all minors, so the court assigned them guardians to protect their financial interests and represent them in court. Now, I guess some of the older children could have been apprenticed out to nearby farms, but as I said before, this would have been typical for the period. Thanks again for watching my video. If you've got any suggestions or feedback, please leave them in the comments. Thanks a lot.